Is an irrevocable trust protected from Medicaid in New Jersey? Long-term care can be one of the most pressing financial challenges aging individuals face in the United States. In New Jersey, where the cost of a private room in a nursing home averages $12,700 per month, many people look to Medicaid as a financial safety net. But qualifying for Medicaid is not simple. For those with too many assets, eligibility becomes a hurdle. That's where an irrevocable trust may offer protection. New Jersey law allows certain planning tools to help preserve assets while still qualifying for Medicaid. One of the most effective tools is the irrevocable trust. Unlike revocable trusts, which leave assets within the control of the creator, irrevocable trusts remove the assets from personal ownership. That distinction makes them non-countable by Medicaid. However, New Jersey's 5-year look-back period can complicate things. If assets are transferred into an irrevocable trust within 5 years of applying for Medicaid, penalties may apply, delaying eligibility. That's why timing and legal structure matter. A lawyer can help you set up a compliant trust to meet Medicaid's strict requirements. Consulting an attorney before moving forward is highly recommended to ensure protection and compliance. Placing your home or assets in an irrevocable trust can protect them from being counted against you when applying for Medicaid in New Jersey. But to truly be protected, the trust must be created and funded at least 5 years before your Medicaid application. Otherwise, the state may treat the transfer as a gift, potentially delaying your eligibility. When done correctly, however, an irrevocable trust ensures your assets are removed from your name and estate. That separation makes it far more difficult for Medicaid to claim those assets for repayment. With the help of a law firm experienced in estate planning and elder law, you can avoid costly mistakes and better protect what you've worked hard to build. An irrevocable trust is a legal entity that owns assets on behalf of beneficiaries. Once created, it cannot be altered or revoked under most circumstances. A trustee is named to manage the assets, and the grantor gives up control. Because the trust owns the assets, not the individual, they're shielded from Medicaid's asset calculations, outside creditors, and certain taxes. However, to maintain protection, neither the grantor nor their spouse should serve as trustee or be named as a beneficiary. This structural integrity is what makes an irrevocable trust effective in Medicaid planning. The trust pays its own taxes, and because ownership is legally transferred, the assets are no longer considered part of the estate. Creating an irrevocable trust also offers tax advantages. Assets inside the trust are not subject to capital gains taxes or inheritance taxes upon the grantor's death. This can significantly ease the burden on heirs. In contrast, if you use a standard will, beneficiaries may face estate or inheritance taxes. A properly structured irrevocable trust helps avoid those outcomes. With support from a knowledgeable attorney, you can set up a trust that protects both your wealth and your family's future. To protect your assets and navigate Medicaid's rules effectively, the Matus Law Group can help. Reach out at 732-785-4453 or visit us at 125 Half Mile Road number 201A, Red Bank, New Jersey, 07701 to schedule your consultation today.